Further hearing in the appeal to Lifestyle Equities in another against Ahmed in another.
Mr. Knox, thank you very much for the news which we've received. I'm grateful.
My Lords, we finished yesterday in an analysis of Mentmore, and I just reached the end of what in my submission was the ratio of the Mentmore case. And we were moving into Mr. Justice Ledain's broader propositions. Now, I'm quite conscious of the time that's available for finishing this ground and also to advance my appeal and the other things. So what I was going to do in respect of the rest of Mentmore is to rely on Lord Justice Slade's analysis of it in the Sprite-Brand case. And if I could refer you to that for your notes, my Lords, it's the relevant passage begins at page 1319D.
Sorry,
1319D.
319.
To the end of the judgment, which is 1325. There were, however, three observations I just wish to make in respect of the end of that. So if I could take you, please, to page 1324, which is the penultimate page of that decision. And then the last paragraph on that page, which continues on to the next.
Just a minute.
Apologies. Thank you.
1324.
My Lord, yes. And it's the last paragraph on that page, which continues on to the next, which I invite you to read, please. It's the one that begins in contrast.
Yes.
My Lords, the first of the 3 points which come from that is a general observation that as an overall finding, Lord Justice Slade indicated that every case will turn on its own facts, and there isn't any particular set of circumstances which either immunise or make guilty any particular person. It's clear from the first sentence in my submission that the test he was seeking to apply there was simply that Lord Justice Atkin had laid down of a director who'd ordered or procured the relevant acts. And in my submission, that is the correct approach, the unqualified approach.
Sorry, at some point you're going to give us the ingredients, the common design in this context with a strict liability tort?
Well, in my submission, my Lord, the ingredients of common design are those set out in the Sea Shepherd case. So they're of general application, so there's no special provision in a strict liability tort. The only point to note in respect of strict liability torts is the point that was made by Lord Neuberger in the Vestergaard-Fransen case, which is that there is no mental element. It's clear that as soon as one engages in a common design to procure the act being done, that one is then liable.
Who is the common design between here?
In the existing case,
yes.
It's between each of the directors and their company.
Between the two of them, or between the individual director and the company?
It's between the individual director and the company, my Lord.
You surely need two human beings to have a common design.
Well, in my submission, no, my Lord.
Well, how can you have an element of tacit agreement with an artificial entity unless there's somebody agreeing on its behalf?
Well, in my submission, my Lord, there are necessarily, as a matter of law, two independent entities. There is the director, there is the company.
But a company only acts and furthers a design through its actors, and who is the actor? It can't be the director acting with himself, forming a design with himself.
Well, no, but then in this instance, particularly in respect of Mr. Ahmed, the execution of the act was undertaken through other aspects of the company. So whilst he may have been the chief decision maker, he wasn't the only person, the only human agent who caused the company to undertake the acts of infringement. So
Well, unless there's some finding that he did have a common design with some other human being, I have a problem with that way of putting the case. Well, it's distinct, I think, from the direct and procure argument, isn't it?
Well, my Lord, absolutely, yes. They are two different approaches to the imposition of joint liability, and that's made clear in the Sea Shepherd case, particularly in Lord Toulson's judgment. He indicates in that case that justices were dealing with common design, not the different principle of procuring or authorising.
And which is the primary way you put it in this case?
Well, I relied equally on both, but and the judge found equally that both ways were made out. But
in the case of procuring and directing, how has that been put into effect?
In respect of the factual findings that the judge made, my Lord.
Well, the key points. My Lord has asked you a question in relation to common design.
Yes.
Who are the actors in that common design?
Yes.
And I'm just asking you if you'd be so kind just to summarise in a very short submission in relation to the procurement.
Yes. What the key
Ahmeds
facts
have
are.
procured whom to do what?
So in each case, the Ahmeds have procured the company to undertake acts of trademark infringement. In Miss Ahmed's case, it's more straightforward because her role was to choose and display and to execute the sales of items. The contract of sale, of course, being with the company, so she plainly, in my submission, procured the company to make those sales. In respect of Mr. Ahmed, the findings were that he was the ultimate decision maker in respect of the use of the signs, which were held to be infringing by the company. So
he procured the company to act in a particular way.
Yes.
And the operative mind, the directing mind of the company for this purpose is essentially his own mind.
Well, yes. Yeah. And in my submission, that must be consistent with the long line of cases which I began to take you through yesterday, that directors procure their company through the history of these cases frequently. My Lords, I'd made my first point about that paragraph of Strike Brand. The second point, my Lords, is to highlight a more specific aspect of the first sentence, and that is that here, where Lord Justice Slade was dealing with what he considered difficult cases, those on the boundary, where they might involve questions of degree, he gave an example of the sole part in which a director played being that of voting in favour of a relevant resolution at a board meeting. And that being, and the point I take from that, my Lords, is that is language that appears again in MCA and Charlie. But in MCA and Charlie, Lord Justice Chadwick appears to have elevated it close to an immunity. So if a director only votes at board meetings, then in Lord Justice Chadwick's view, then they will not be liable. But in my submission, Lord Justice Slade here, and I think this sentence is probably the genesis of that finding in MCA, but Lord Justice Slade here doesn't identify it in any way as a factor that would give rise to an immunity. It's merely a factor that is to be taken into account in the overall assessment.
But if we're to provide guidance on this analysis to a judge at first instance,
Yes.
what are the relevant factors in a case such as this which would, in your submission, take it over the line to an infringement?
Well, anything in my submission which is a direction to do, it's unfortunately going to be slightly tautological, my Lord, anything which is a direction to do the act which turns out to be infringing is a procurement of that infringement by a director. The cases, I think perhaps what Lord Justice Slade and then later Lord Justice Chadwick had in mind when they're talking about voting at board meetings is a situation where there is a committee meeting. One person in that room says on the minutes, yes, tick, I agree with the proposition, which is that we are going to sell a new range of products, and that new range of products turns out to be infringing. It would be difficult, I think, in those circumstances where the person had merely occupied that role to say that they were procuring the company to undertake those acts. If, however, there's evidence that a director approached the board and said, this is what I want you to do, this is how the company should act, and I seek to persuade you to vote for this, then that may be on the other side of the line. I think it's always going to be difficult in the abstract to try and identify particular circumstances which either will or will not give rise to liability. And in my submission, Lord Justice Slade was careful not to do that, merely to say, in general terms, as he ultimately concluded, following Lord Salmon, each case turns on its own particular facts.
Thank you.
The third point, I think, is on the same lines, my Lord. Also, towards the end of the paragraph, Lord Justice Slade indicates that in some cases in English law, it may be material to decide which side of the line participation fell by taking into account broad considerations of policy, or might be relevant to take into account knowingness, deliberation, willfulness, and so on. Again, I say in respect of that, those are not, quite plainly, they're not requirements. They are merely indications of facts which, when considering all the circumstances, might in a particular case be relevant. But they certainly weren't said to be, certainly weren't elevated to the status of being a test or part of a test.
Mr. St. Quentin, on the facts of on this case,
yes.
Sprite brand, Lord Justice Slade didn't have to come to a concluded view.
He didn't have to come to a concluded view as to whether the facts established it, but he did have to come to a concluded view in my submission as to whether a requirement for what he described as a mens rea element was a feature of English law.
Yes, and he proposes a test as to which side of the line the particular case might fall. I have some difficulty with seeing how that might operate. Doesn't it reduce it to considerations of policy?
Well, in my submission, my Lord, it shouldn't in almost every case, because in most cases, particularly this case, the case that you're seeking to adjudicate upon, the position was clear. The judge expressed it. He had no doubt that the Ahmeds were liable for having procured their company to commit a tort. The approach Lord Justice Slade says in my submission, when he starts that paragraph with, in contrast and other hypothetical facts, difficult questions of degree might arise, noting that he's there talking about cases in the margins where things are not clear one way or the other. And it's only in those cases where a director is on the cusp of either being liable or not, the considerations of policy that may involve the nature of his role need to be taken into account.
So it's not possible to elaborate the hypothetical test beyond what Lord Justice Slade says in this judgment?
My Lord, yes, and particularly relying on what Lord Justice Atkin had said 100 years ago in the RS and Cyril.
Thank you.
My Lords, I'm going to... I asked you to read Professor Flanagan's article yesterday, or parts of it, lots of parts of it. There's a second academic article that I also relied on in my written note, one by a Professor Lowe. I wonder if I could also ask you again after the hearing to read some pages from that, only 3 pages of that one, you'll be pleased to hear, beginning on page 2297, after footnote 147. Essentially, they're Professor Lowe's conclusions.
When reading Professor Flanagan's article last night, he discusses in the course of it the tort of inducing a breach of contract and why it is that in side and butt or such like cases the director isn't liable.
My Lord.
And an explanation he gives, I'm looking at page 2223, is that at the bottom of that page, he says that in this sort of case, to put it another way, the corporation was not induced to breach the contract. Its own internal decision-making mechanisms produced the breach. No external force influence on the part of someone lacking authority was involved.
Yes.
I just wondered whether one could seek to transfer that kind of reasoning to a case such as this, and to say that where the director, acting in the course of his authority, bona fide, gives instructions to someone within the company, say, which produces a breach, it's just the internal decision-making mechanisms of the company that produce the breach. You cannot say that the corporation was induced to commit the tort.
So,
transferring that from breach of contract to tort.
So, my Lord, conveniently, this is the next aspect of my submissions, is to deal with my learned friend's proposition that this approach in inducing a breach of contract can be transferred. In my submission, it's clear in the context of that whole section of Professor Flanagan's article that he is confining himself exclusively to the approach in the tort of inducing a breach of contract. And
I know he is, but I'm just wondering whether his reasoning could be developed.
But the basis on which he confines himself is to indicate above on page 2223 that the distinction that arises in inducing a breach of contract is because the acts complained about are at their core complaints about a contract, and that the approach to breaches of contract is different. So the company and the claimant in an inducing breach of contract case have a relationship with each other that they have chosen to have through the contract. The way in which a company performs, or if it chooses to breach a contract, is through making a decision. And that's always going to be inherent in the nature of a breach of contract, that someone within the company must have decided that happens.
You might say that about committing a trademark infringement, mightn't you? It does seem a bit odd that the director, simply acting in the course of his authority on behalf of the company, is said to be procuring or inducing the company to commit the tort.
Well,
as opposed to it simply being the company committing the tort in that situation.
So in my submission, my Lord, there is a distinction. Perhaps if I could develop this through my submissions that I was about to make and come back to this point, if
of course,
still needs assistance.
Yeah,
because
I've just thrown it out because you mentioned Flanagan.
No, of course, my Lord. It was a good opportunity for you to get the question in. The case I wanted to take you to is the Arthur Putra case, which my learned friend took you to, the Court of Appeal of Singapore. And that, in my submission, that also deals with this point. So that the relevant passage begins on page 1922. Paragraph 74. And it's about 40% of the way down that. Actually, my Lord, perhaps if I just invite you to read the whole of paragraph 74 and I'll make my submissions on it. So, my Lords, the first point that comes out from paragraph 74 is very closely related to one I made to you yesterday. First thing about the decision of McCarty, J and Said and Butt, where he was careful to distinguish between his findings on procuring a breach of contract and other torts, and that's observed in the middle of that paragraph. The Singapore Court of Appeal in the Arthur Putra case goes on to talk about how that same principle is also the law of Singapore, and they cite in support of that 2 cases, the Gabriel Peter case, and then at the end of the paragraph, TV media. It's not 100% clear from this paragraph, but they are both also decisions of the Singapore Court of Appeal. The first one you see, it was by the Chief Justice of Singapore. The second one also is. So I take from that it's also the law in Singapore that there is a distinction between the approach to joint liability in procuring a breach of contract and other torts. Continuing, my lords, to the next paragraph of this case, 75, the first proposition in the next paragraph wonders whether it's legitimate to permit directors to be immune for their procurement of companies' breaches of contracts, but not for other torts. And they note that Lord Justice Dillon, in the Welsh Development Agency case, held that this immunity, as it were, for directors in a procuring case is anomalous. And, my lords, that case, if I may take you to it quickly, because it's a short paragraph just before returning to Arthur Putra, is at 1865. And at the bottom of 1865, at H. So if I just invite you to read the last paragraph of page 1865, if I may. The point I take from that, my lords, is that if something's gone wrong, it's not the general proposition in respect of tort law, it's the proposition in respect of procuring a breach of contract. That's the special case. So it shouldn't be extended. If anything should happen to it, it should be reduced.
You don't go as far as to say that we should cast doubt on that principle?
Well, my lords, it's not before you today. I mean, I would invite you to. I think Lord Justice Dillon is correct, but it's not necessary for your decisions.
He certainly, in the next paragraph, said it wasn't for the Court of Appeal to interfere with it because it's been established for so long.
Yes. Yes.
You say we should put it in a box marked anomalous.
My lord, yes. Returning to Arthur Putra at page now 1923.
Sorry, 19. I mean, what goes on here is the Singapore court identifies the arguments going both ways.
Yes.
And then ends by saying there's much to be said for both sides of the argument.
Yes.
It doesn't actually come to a view on it.
It does. And what they do usefully, though, is they do set out some of the propositions.
Yes.
In my submission, they're wrong at the end to say there are good arguments in both directions. There aren't good arguments in my submission, of course, against my case.
So you rely on the case, but basically say they're wrong.
Well, I rely on...
Around one half of it.
I rely on the parts of the case, exactly, my lord. I rely on the parts of the case which support my argument. But those parts of the case in my submission are compelling. The principal one, there's a reason set out in the quote in paragraph 76, which is from another judgment. Sorry, in fact, it's not. It's an explanation about a judgment. From the fourth line in, it explains since a contract is made between a company and a third party, the third party's recourse in the event of a breach is ordinarily limited to the company alone. But then they say, and this is important in my submission, a person injured by a company's tort, the original emphasis, is likely to be in a vastly different position. The third party victim has not, in any meaningful sense, consented to deal with the company. He's a complete stranger. There is thus no obvious reason for confining responsibility to the company. On the contrary, the law's usual response in such circumstance is to attribute responsibility to all actors who are personally implicated in the tort. That, in my submission, is the important, or is an important reason for not extending that principle to positions, to general torts. But as you say, my lords, sorry, Lord Richards has indicated, of course, you saw yesterday that the case doesn't ultimately reach a conclusion. What they rely on against my position is part of Professor Tan's article, but that, in my submission, is an article which involves some academic gazing into the future. It isn't a proposition which is said to arise from particular cases. It's a proposition that Professor Tan suggests perhaps this is a solution to amalgamate or to reconcile these slightly different propositions. The position of the law as it stands in my submission is that for torts other than procuring a breach of contract, the normal position is that all actors responsible for the acts are liable.
Well, what Professor Han seems to be indicating is even if there's a prima facie liability, there might be a defence of justification if the director is acting honestly pursuant to their duty, in accordance with their duty to the company.
Yes.
That was the sort of argument Mr. Knox was making
precisely.
yesterday.
And the basis ultimately for Professor Han saying that is to say that company law is somehow relevant to this question about tortfeasance.
But it could just be agency law, just company law, that if the agent is acting bona fide in accordance with their duty of loyalty to their principal, unaware that they're committing a tort, that might amount to a defence. That would be the line of...
perhaps that's the line of reasoning. In my submission, my lord, the approach is that agents are liable for the torts that they commit in the course of their agency.
Can I just pursue that with a principal and agent? Assume that the principal is not a company.
Yes.
Assume that it's a human being.
My lord.
Who's carrying on a business, but has, let's say, an agent doing some or all of the business
Yes.
on his behalf. And the agent, acting on behalf of the principal, does an act which is an infringement of the sort we're talking about here.
Yes.
Now, as I understand it, to arrive at joint tortfeasor liability, relevant for these purposes, making the agent liable, there has to be a common design.
Well, to make the agent liable...
Yes, the principal is liable because the principal
is liable for the agent's
issued the infringing article.
Yes.
But what is sought to do is to make the agent liable as an accessory.
I see. So, in your example, my lord, the principal is issuing the act.
Yes, it's the principal who is putting the goods, the infringing goods, out for sale.
But the sale is being made by the agent.
Yes, it's the agent.
So there's a complexity then that the agent making the sale, in my submission, would be primarily liable as well as being jointly liable.
Well, no. Well, I'm assuming it's a case put in accessory liability.
Well, in that case, yes, the agent in that circumstance would be liable through common design.
Where is the common design? Because all the acts have been done by the agent. But the agent has made the decision on behalf of the principal. The principal has not actually been involved in this at all.
In the circumstances of the agent acting within his authority, then his authority would indicate a design to undertake those acts.
A design.
Common.
So you say there's a common design between the agent and the principal in my example.
Yes, in your example.
Yes.
And
even though there's only one human being who's ever use their mind in relation to this?
Well, my lord, yes. There's also, there's a complexity with the general liability of principals for their agents' acts. Anyway,
that's a different matter. The vicarious liability. We're not concerned with vicarious.
The reason is in a standard principal-agent situation, the question doesn't frequently arrive because of
It was a matter of principle. It would, your case is,
as a matter of principle,
understand
still
it, the
common
agent
design.
would be liable as an accessory and therefore as a joint tortfeasor.
Yes, and certainly, my lord, in that situation, the agent who's ultimately selling the goods.
Well, no, because he's not. Leave aside. Assume for the moment that it has to be they have to be the person sold in the course of the person carrying on the trade, which is the principle.
Yes. Well, so then the agent has procured the principle. So in addition to common design, the agent has procured the principle to make the sale.
Well, what is? I thought that was common. You say there's a separate category.
Yes.
Of procure. I see.
So yes, so there are two
Well,
sort of entirely.
the answer to this question.
Yeah, there are two entirely separate routes to joint liability.
Two separate routes. Yes.
Right.
I see.
The final proposition my learned friend made in respect of seeking to apply this concept that the director should be treated as the company was to refer you to the decision of Justice Hardy Boys in the Trevor Ivory case, which you were taken to yesterday. You were taken particularly to a passage at page 5078. I wasn't planning to take you again to that passage. I was going to take you instead to a third academic article that I rely on, which deals with that case. And that's the article by Mr. Campbell and Armour. And their article, the relevant part of their article begins on page 2180 through to 2184. And it's under the heading, the disattribution heresy. And perhaps, my lords, given the time, I won't take you to that now. If I could again ask you to read those pages 2180 to 2184, the proposition that the learned authors of that article make is that the idea that acts of directors, which are deemed to be acts of the company, are then no longer acts of the director themselves, is a mistaken extension of an identification doctrine which arose from Tesco and Natras in other cases, and that is an inappropriate and unjustifiable extension of that principle. So, my lords, I commend that to you as well. Given the time, I think I won't be able to deal with the other cases that are mentioned in our written arguments, but they're mentioned and dealt with in our written arguments. So I rely on that. I just wish to make briefly one point about my learned friend's reliance on the Companies Act in section 172, and that is simply this. All my learned friend's submissions on that proposition arise from an idea about what section 172 requires directors to do. But at no point did he seek to undertake an interpretation of that section to see, in fact, what it requires. And of course, my lords, the modern approach to statutory interpretation is to have regard to the purpose of a particular provision and to interpret its language so far as possible in accordance with that purpose. And the simple point, my lords, it can be no part of the purpose of section 172 to have obliged directors to undertake unlawful acts. And as a matter of interpretation, it simply should be read as or understood to be limited to directors acting in a lawful way. And that, in my submission, prevents all of the difficulties that arise in association with my learned friend's attempts to rely on that. I have one final point on the first ground of appeal, my lords, which is in respect of burden of proof. I've addressed this in my written submissions, paragraph 52 onwards at page 217. I have little to add to what I say there, which is, in essence, this is an affirmative defence, and so it's for a defendant to prove it and to plead it. In my submission, that is supported
Depends how it's conceptualised, doesn't it? But if it were a justification type of argument, then it would be a defence.
Quite well. So exactly as the way that Professor Han or Tan puts it, if it is a justification, then it's a defence that needs to be pleaded and proven. And that is the approach in my submission that's been taken to the exception that Lord Justice Chadwick identified in MCA and Charlie to voting at board meetings or acting through the constitutional organs of the company, particularly by Lord Justice Lewison in the Ottercroft case, which is in the bundle at the relevant passage begins at the bottom of page 1562, where I should say, first of all, at the bottom of page 1562, I won't ask you to read all of this, but it's just for orientation within the judgment. At the bottom of 1562, there is the paragraph numbering in this judgment is peculiar, so both 18 and 20 is the beginning of his analysis of MCA and Charlie. The conclusions in that are on the middle of the next page at paragraphs 19 and 22. The acid test is whether the putative tortfeasor is exercising control through the constitutional organs of the company. I don't need to read more of that. And then the relevant point that indicates the approach that Lord Justice Lewison took to the burden of proof is at the bottom of that page 21 and 24. In the present case, moreover, there was no evidence of what the company's constitution was, no evidence of the decision-making process within the company, no indication that Dr. Rahman, as co-director, played any part in that process, and no evidence that the company did anything other than what Dr. Rahman wanted it to do. So it's only reconcilable, that finding, with the proposition that it was for the defendant to the allegation of joint liability if they wanted to say they fell within the exception that Lord Justice Chadwick had identified to prove it themselves.
What does the exception, the first exception, actually mean? That is, that if there was a vote at a board meeting for the company to actually market infringing articles,
yes.
Why should the directors who voted for it be exonerated?
Well, in my submission, they shouldn't be, but that's the way that Lord Justice Chadwick approached it. And as I said earlier, I think taking his lead from Lord Justice Slade in Sprite Brown, where he'd given an example of a potentially difficult case.
And then why should shareholders be exonerating if the controlling shareholder conceives, directs, procures?
Well, again, they shouldn't be in my submission, my lord. No one should have any particular immunity. Equally, no one should have any presumption against them. The question always is going to be, what have they done? Which, as I said yesterday, curiously, is how Justice Ledane began his judgment in Mentmore. He said it doesn't matter that they're directors, what matters is what they've done. My lords, the final point on burden of proof arises from my own friend's note, which arrived this morning. In that, as I now understand the way that this ground appeal is put, there are two alternative ways in which a director can be found liable. So if my learned friend's right on this, I deal with it in this way. One is that he was not acting bona fide and with reasonable care in the discharge of his duties. And the second is, or he had actual or constructive notice of the rights which the company infringes. Now, even if you're against me on the burden of proof, my lords, I don't understand there's actually a question in this case that Mr. Ahmed, at least, had notice of the rights on which his company is infringed. It's his particular case that he relied upon the Ogham decision. The Ogham decision asserted one of the rights which was ultimately found to have been infringed. He must therefore have had notice of it. And that opposition, the trademark against which that opposition was made was filed in September 2012. You see that in the chronology at page 1037. It must have been shortly after that the opposition was launched, and therefore Mr. Ahmed would have had notice.
Can I just intervene? This note was written in a very considerable rush. I would like, if I may, for clarification, so my learned friend can deal with it. When you see B, he had actual constructive notice of the rights which the company alleges company infringes, it should say actual constructive notice that the act he does will cause an infringement of the rights of the trademark owner. My lord, I apologise. I can see why my learned friend takes exactly the point that he does. But that is the way, I think it is actually the way we have put it in our case before.
Could we have the formal words again, please?
Yes.
Make a note of it.
So B should be, he had actual constructive notice that the act he does will cause an infringement of the rights in question, which is rather different. Because I might know that you've got a mark, but I might genuinely reasonably believe that there's no conflict or risk of confusion. And so I apologise that I didn't get it. I didn't put it right. But with I hope your lordships will accept that it was done in 20 minutes.
It clearly was.
You have my submissions on that proposition already. With that, I'll leave ground.
Just before leaving it, I was just a little bit uncertain. The facts must be such that either he is an agent or a company director or an employee.
Either.
Well, not to worry, Mr. Knowles. It's just flagging up for later on. And with reasonable care and discharge of his duties to the company, to the partnership, to the unincorporated association, to what? And anyway, so I just have difficulty at the moment in following exactly the exact parameters of that formulation.
My lord. So with that, I'll move on just quickly to the third ground. I don't have a lot to add to this, to what I said in my written submissions, which are at page 247 of the bundle. In my submission, there are three fatal points for the Ahmed in respect of this. First is that in any account of profits, the burden of proof to...
which paragraph are we on? I think it was a different page.
Well, it's page paragraph 142.
Thank you.
On page 247. Is where the section commences, at least.
So you're not saying anything about the second ground of appeal, the order?
But Mr. Brown is going to...
Oh, forgive me, yes, you told us that, yes.
Apologies.
Yes.
So the proposition here, the burden falls on the Ahmed to prove any deductions in an account. There is no evidence about the value of their labour. This wasn't a point that was even pleaded or taken before the judge. In particular, in respect of deductions from, in particular in respect of deductions in respect of skill and labour, the position in the law as it currently stands, as I've set out in paragraph 146 of my written reply, is that this is an unusual deduction to make in any event, but as was indicated in Image View and Jack, again, the burden falls on the party seeking that deduction to persuade the court that it's appropriate. And then finally, as I set out in 146.1, there is doubt as to whether there's even jurisdiction to make such a deduction when the people, when the persons in question are directors who may have control of their own salaries.
I found this a little bit difficult to follow in a way because this normally arises where the accounting party has no entitlement to receive remuneration for their work. But what happened here is that the Ahmeds worked and were paid.
Yes.
They received remuneration.
Yes.
Prima facie, they gave value for that remuneration in the shape of their work.
Yes.
Why is the remuneration a profit in their hands?
I should be clear, this ground of appeal does not challenge that particular finding, that their salaries can be and are profits.
Well, can be. I follow can be in the sense that if a salary is excessive, then in a case like this it might be a disguised dividend and would therefore be a profit. But on what basis is it said in this case that it is a profit in their hands?
My lords, the fact of the way it's put was that their salaries were determined, were paid by the company in part out of the profits that were the result of these infringements. The judge found that to be the case, and that he attributed 10% of the salaries they achieved to profit resulting from these acts.
But is he saying it wasn't properly remuneration, it was really a dividend?
No, he doesn't.
I mean, I could understand it if...
He needs to go that far in my submission.
But, I mean, I can understand that he's saying that 10% of the company has got 10% of its remuneration from these items, but how does that feed through into their salaries?
Well, the salaries were variable over time, or capable of being varied, and they were paid, and only paid in my submission, because the company was making profit, including profit from the acts of infringement. And so directly from the profits made by the acts of infringement, money went to the Ahmeds. It was characterised as salary, but in my submission that doesn't make a difference.
Well, you say it's characterised as salary. I mean, it wasn't it wasn't said this was in truth a dividend. That was never part of the case.
It wasn't said that way, no.
No. I mean, I just find it quite difficult if someone is giving value for the money to say that in their hands it's a profit.
Well, if that's the question, one would have to assess how much value was given in response in respect of how much money.
Yeah.
And what we know is this amount of money went from, as a consequence of the infringements, to them. What we don't have is any evidence to suggest how much was expended as a consequence of that.
What do you mean? Sorry, I'm sorry, I don't follow that.
There's nothing on the other side of the ledger to deduct from the payment of this portion of salary that resulted from profits resulting from...
But you're putting it almost there like a sort of tracing claim, that these are illegally obtained profits and they're traceable into the hands of a third party. But even then you'd be met, wouldn't you, with the... If someone is being paid remuneration, a bona fide purchase for value without notice, well, you might say they did have notice, but it's a different concept. The fact it's paid out of the profits doesn't actually follow that it's profits in the hand of the recipient.
Yeah. The factual finding the judge made was that this sum of money in the Ahmed's hands did come.
Yes, I think. Could you just give us the reference? We won't go to it now, but if in the judgment below that deals with, in the first instance judgment that deals with. Of course.
So, my lords, it might be convenient, given that's otherwise the end of.
Yes.
Given the time, if I hand over to Mr. Brown, and I'll give you that.
By all means. I mean, can I just ask you one other question? I would have thought that in computing the profits of the company, you would deduct the legitimate expenses, which would include, obviously, any goods supplied and so on, but also salaries.
Yeah, well, typically, yes, that would be done, my lord.
So the salaries, if you like, would be attributable to the gross profits, but it wouldn't be in arriving at the company's profit. You would actually deduct, wouldn't you, the salaries?
So often that
on the basis that this was a necessary expenditure in earning the profit.
Well, so often that is done, but
actually, what was done here? Because you never did have an account of profits against the company.
Well, it was calculated, but it wasn't ordered.
All right. All right.
But, yes.
Is that dealt with in the judgment as well?
It is.
It is. All right. Well, at some convenient time, you can give us the reference. Thank you.
Thank you. Mr. Brown.
May it please your lordships, I'm addressing an extremely discreet point now, and I'll try and be correspondingly brief. The Ahmeds say that the Court of Appeal was wrong to order an account. We disagree. in my submissions, I'll be referring to the pages by their page references in what my Lord Richards called the big bundle. That's the one that's in excess of 5,000 pages. But, my Lords, you might handily have, if you've got it separately, the written case of the Ahmeds in respect of their second ground of appeal, the account. Now, the page reference for that in the big bundle is 186.
127 in the hard copy.
Grateful, my Lord. I adopt what we have said in our written case in respect of this, and, my Lords, I'm not going to repeat any of that. What I'm going to do, because I consider it maybe most useful for your Lordship, is simply to go through the few short paragraphs in the written case of the Ahmeds and say why I say all of them contain fallacious reasoning. You'll see that our position in respect of this ground of appeal is encapsulated in one line in the reasons at the end of our written case, because we say that the discretion to order an account was exercised properly on a proper basis. Can we start, please, with paragraph 132, which is the sort of overarching paragraph in the Ahmed's case? I'm just going to quote a section of it. The Court of Appeal was, I'm starting on the last line, wrong in law to hold that improper is substantially wider than unconscionable, such that, as the court held, the acts which render the defendant liable are themselves improper conduct. Now, if your Lordships wouldn't mind just going to what the Court of Appeal said. This is on page 356.
What paragraph?
61. I'm going to start about halfway down. I agree with Mr. Justice Henry Carr, as he said in paragraph 23 of that judgment, it's a reference to GSK and Wyeth, that a basic principle of accounts of profits is that there should be some unconscionable or improper conduct by the defendant. In saying this, I emphasise that this does not limit the remedy to cases of unconscionability. However, nor does it impose an extra hurdle for a rights holder whose rights have been found to be infringed by a defendant. The acts which render the defendant liable are themselves improper conduct. So it's no part of that reasoning, my Lords, and this is the straw man that I say is built up by paragraph 132, that the Court of Appeal said that improper is substantially wider than unconscionable. All that is said here is that the words mean different things, and I dare say that it's not an adventurous submission for me to say that that is why Mr. Justice Henry Carr used two words separated by the word or, and why Lord Justice Burst did too. The Court of Appeal happens to be correct that the remedy of an account of profit is not limited to cases of unconscionable conduct. We needn't turn it up, but your Lordships will search in vain for references to unconscionability in sections 10 and sections 14 of the Trademarks Act 1994. In its essence, section 14 says that the infringement is actionable, and the remedies that are available are all the remedies that would be available for infringement of other property rights, including an account. Could your Lordships now please turn to Snell's equity, which in the big bundle is at 5,600. Now, I have in mind here, and I want to take your Lordships to this, the observation made by Lord Legate in the course of my learned friend Mr. Knox Casey's submissions, that one ought to really look at the policy of IP law, not the policies of equity, when one is determining the proper circumstances in which this discretion is to be exercised to order an account of profits. And we've got that in SNAL, which goes through where this relief is available. At paragraph 20-042, which is on 5600. And could I invite your lordships to read, please, from the words after footnote 134, as to intellectual property infringements, through to made to account on the next page.
Down to where, sorry?
Down to on the next page, my lord, the words made to account, so the penultimate sentence of the paragraph.
Yep.
Do we have Microsoft Corp against Plato Technology?
We don't have it. We can produce it after the hearing if you like. I have read it, and it is a case which does what Snell says it does. It's not in the bundle because, if I recall correctly, it was summary judgment. So what your lordship might have noticed there is that there's an unevenness, if I can put it that way, as to whether or not unconscionability is in play. Your lordships can note that in paragraph 1, in footnote 139, the case my learned friend referred to yesterday, Colbeam, is mentioned. That's a 1968 Australian case. And you'll see it's consigned to a footnote, but it's a footnote that's beneath text that also consigns it to the historical position. Because what is said here is that a strong line of authority predating the Trademarks Act 1994 exempted innocent infringers from liability. However, it has been held under the 1994 Act that an innocent infringer may be made to account. Now, I don't need to take your lordships to Colbeam, one, because my learned friend didn't.
But why has the Act changed the position?
Well, there's no element of... Well, first of all, I don't accept that it necessarily has, as a matter of English law. And secondly, there's no element of unconscionability that needs to be proved as a precondition for the discretion to order an account of profits to be exercised after the action has been proved as against the relevant alleged infringers. So in respect of Colbeam, as I say, I don't need to take you to it, just to say that it's a description of the law as it stood in Australia in 1968, and it of course refers to our law. It doesn't purport or say that it's a comprehensive survey of our law, but it's not going to assist your lordships in my submission in 2023 in determining circumstances in which an account should be ordered under an English statute enacted in 1994.
Is the principle set out in footnote 133 on page 5600?
Let me just turn that back up.
A sort of corollary of the injunctive relief, and one is securing from the infringer a disgorgement of the profits derived from the invasion of the intellectual property rights of a proprietary character.
My lord, precisely, and that's why I alluded earlier to Section 14's reference to the remedies being available being the remedies that are available in respect of the invasion or infringement of other property rights. And I'm going to come, Lord Richards, to a comment you made yesterday in relation to Keach and Phipps, which was... Okay?
Footnote 133 is referring to user damages, I think, not account of profits. Though.
Yeah.
There are actually three different things at play. Damages are aimed to remedy a loss. user is on what is sometimes called a royalty basis.
Yeah.
And disgorgement of profits is something different again, my lords.
Yes.
Are you going to take us to Wyeth, to what Mr. Justice Henry Carr said?
The reason I had to turn back just now is because I was already there, so I'll go there immediately. It's on 3065 of the big bundle. My lords, this is in my submission really important. And I'd ask your lordships, therefore, to read paragraphs 23 through to 25 of this judgment, and then I'll comment upon them if I may. So, my lords, this is a modern decision of the English High Court by Mr. Justice Henry Carr. And what's interesting about this, keeping in mind my comments about how Snell consigns Kolbein to history, is the following. So, first of all, if one reads the excerpted passage from Mr. Justice Pumphrey's judgment in spring form, another modern case, you'll see the purpose there being described, and it's the disgorgement of profits improperly made by wrongful acts. Note no precondition of blameworthiness or unconscionability. And then we've got in paragraph 24 the word similarly, which indicates to me that there's no necessary identity between that excerpt from Mr. Justice Pumphrey and what Justice Windayer is saying in Kolbein.
I would think similarly means to similar effect, doesn't it?
Yes. In 25, that is...
I don't find 25 very satisfactory, because what are all the circumstances of the case? I mean, I thought your case has to be that it's always appropriate, isn't it? What are the circumstances in which it isn't appropriate?
Well, we set out in our written case some of the circumstances in which we say it isn't appropriate to order an account.
This is a very odd case, isn't it? Because the claim was for an account of profits in respect of past infringement, and the judge ordered that. But there was also an application for an account of future profits, and he declined to order that, and I think you see the reason for that in paragraph 26. I think that is probably quite important to the facts of the case.
Yes. In response to my Lord Legate's question, what I say in respect of Kolbein is that it's quite important to actually read what was said in that case. Right. And that's a case of knowing infringement, and that's the context in which those comments were made, and that is why Mr. Justice Henry Carr describes the case in that way and just says, Mr. Justice Windayer gave knowing infringement as an example of unconscionable conduct. And I agree that that's unconscionable. Picking up on that theme, what I say in relation to paragraph 132(1), which is this sort of, if I can put it this way.
Wait, 131 of?
This is back in the written case now, which hopefully...
Appellants written case, 132.
Exactly, the Ahmed's written case.
Paragraph.
Yeah. So it's where we were before. It's the first subparagraph, 1321. So this is the argument that improper suggests some form of bad faith, or at least indifference or carelessness. I have a short submission about this, which is that's wrong as a matter of normal.
Sorry, can you come back to paragraph 26 of Wyeth, which I drew your attention to? Why, as I said, it's a slightly curious case because there has been infringement in the past, and the judge orders an account, but he's asked to order an account of future profits and declines on the grounds that he says at the end of 26, the continuation of infringement would not be unconscionable. So what does that mean here?
Well, my lord, all I say about that is that those are peculiar facts with very strong...
deliberate infringement, but not an unconscionable one, and therefore no account.
And my lord, it must be deliberate.
Yes, it must be deliberate.
After this judgment.
Yes, absolutely.
But why is the past treated differently from the future? I mean, either it's all unconscionable or none of it.
Well, my lord, I'm not saying I agree with the result.
Well, I know, but
in respect of this, but I can see that there were strong public interest grounds.
There were indeed.
At work. I don't think I can take my submissions on that any farther.
But, well, I suppose you submit to us it's wrong, do you?
If needed, yes. I mean...
Well, what do you say the principle is? I mean, what are all the circumstances of the case which are relevant?
So, some of them are listed in our written case. There are examples where... In fact, I'll come on to address this in the course of my submission. So, you'll see where I say it is possible not to order the account of profits. And I'll come on to say in relation to that, as efficiently as possible, that those circumstances aren't present in the instant case. The semantic point in relation to 132.1 is just one with which we disagree. I suggest those judges to whose judgments we've just referred used unconscionable and improper, used two words with or in the middle, because they were suggesting that they weren't synonyms, they had different meanings, and an account of profits could be ordered in both circumstances. In my submission, improper, one of the meanings of improper, which is pertinent here, is being contrary to a rule or law. And that is the context in which to read the citation in the Ahmed's written case of what Lord Justice Burse says, which is that the acts which render the defendant liable are themselves improper conduct. That's an elegant way of saying in my submission that the acts were wrongful and therefore improper.
I mean, unconscionable in the equitable sense means only that knowing the facts that you now know, it's against conscience to keep the money. It doesn't mean necessarily that you acted in bad faith or dishonestly or anything of that sort. It's knowing that the money has been earned through the use of somebody else's property. It's against conscience for you to keep it.
My lord, you've taken
in that sense, it's not even improper. It becomes improper to keep it because it's unconscionable to do so.
My lord, you've taken that submission out of my mouth.
Sorry about that.
No, I'm grateful. You saved me making it myself. So that's an interesting example of where it's the retention that is unconscionable. That doesn't necessarily connote a prior blameworthiness in my submission. And I was also going to pick up on something that your lordship said yesterday, which is that one can have an account of profits and the associated relief of an account of funds in breach of trust and breach of fiduciary duty cases where there is no blameworthiness whatsoever. And that's because the trustee or fiduciary has care of someone else's property. And here we're in circumstances where profits have been made through the use of someone else's property.
The explanation for why an account wasn't ordered for the future was that Pfizer wasn't pursuing an injunction, and the account for the profit for the future would be exactly the same as an injunction, which is in paragraph 27.
What is it here?
But I mean, if the discretion shouldn't be exercised to order an account of profits, then presumably the claimants are entitled to their claim in damages, either for damages proved or for a royalty.
Yes, they have to make the election. And what's interesting about your Lordship's question is that, and this particular area of the law, is that they're entitled to be ruthless in their election.
Well, if they make their election, can they, and if the judge says, well, in the circumstances I'm not going to order an account of profits, can they revert to damages?
I don't know. I'll ask my co-counsel, Mr. St Quintin, if that's
Well, it's too late now, anyway, to claim damages, I think.
If that's ever happened to him. But the point I was going to make about ruthlessness is that one can choose the remedy that has the highest monetary value. It's quite an odd thing in those circumstances, given that the law gives the successful claimant that choice, for the court to turn around and say, well, no, damages is all you can have, notwithstanding that you're entitled as a matter of law to elect. Coming back to your questions, my Lord, can we turn back to the Court of Appeal judgment, please, because some of the factors are set out there where a discretion to order an account might not be exercised. Page 357, please.
Paragraph.
So paragraph.
So I'm going to start, please, on paragraph 62, and if you could simply read, my Lords, through paragraph 62 through to 65. The other pertinent passage, which I'll read, is in the top of paragraph 60. I read this because it has two purposes for the submissions. The discretion is one to be exercised in all the circumstances. The claimant's choice is an important factor. As Mr. Justice Henry Carr said in GSK, it's standard to allow the successful patentee to elect either for an inquiry as to damages or an account of profits of past infringements. The same is true for the holder of any other intellectual property right.
For what it's worth, my experience, rights holders are reluctant often to apply for an account of profits because you're very much in the hands of the infringer, assuming infringement has been found, as to whether profits were made and if so, what they were. Whereas if one elects for damages, then, as my Lord Stevens mentioned, I think, a moment ago, at least one's going to get a reasonable royalty for the invasion of the right, subject to any innocence defence and so forth. But,
my Lord, yes, I can see why that is so. And to come back to your Lordship's question, there are four circumstances, as I can ascertain on the law, where the discretion might not be exercised to order an account. One is if it's disproportionate to do so, and in that proportionality analysis, I would have in mind things like use of the court's resources, costs to the party of conducting the account, And given that the successful claimant is entitled to some information about the profits that have been made before electing Island Records, the amount of profits that it is supposed have been made. So all those things would go into the mix in terms of determining whether or not it's proportionate. Now, in this case, as against the individuals, the judge ordered that they disgorge profits of just over £800,000. So I say the proportionality was obvious, obviously in favour of exercising the discretion to order an account. And in relation to that, my point on proportionality, which is relied upon by the Ahmeds, they say that the judge, Lord Justice Burse, didn't conduct any proportionality analysis. Well, their case on proportionality, the case on proportionality was entirely unparticularised. They haven't advanced a positive case. Why doing an account, in this case, was disproportionate? And that, I say, is fatal. The second circumstance in which an account of profits might not be needed is where the profits are simply known. Imagine, if you will, my lords, a well-organised company that has accounts for the relevant period that show the profits, that doesn't want to try and deduct anything else from those profits. We don't need to look at it. One of the throwaway comments, which I think is prescient, in Grant and Mumford's book, Civil Fraud, about the account of profits, is that it almost makes no sense to have deductions from profits, because the profits figure is after deductions. We'll come to tax later, obviously. The profits figure should be as is, and that's why the burden is on the defendants, the wrongdoers, the tortfeasors, to justify any further deductions. The next point, which is mentioned in the judgment, is delay.
I can't understand why the profits are known means you don't order them to be paid over.
No, you do order them to pay.
You were giving discretion for not ordering an account of profits.
Sorry, let me be clear about the submission. So in my submission, I'll come to this very shortly, an account of profits is a remedial process which has as its objective working out the amount of profits that the claimant is entitled to by reason having been successful in the underlying.
Well, it simply means calculating the amount and having it paid, doesn't it? And if the amount doesn't require any calculation, you just proceed to payment.
Exactly. And I would say that then doesn't involve the ordering of an account of profits, because the account is a formal process of accounting.
Well.
Forgive me if I hadn't made that clear. The next circumstance, and I have to accept this, not least because it features in a judgment of Lord Kitchen, in a formal capacity, is where the infringer is entirely innocent. That is a circumstance in which the court might exercise its discretion not to order an account of profits. The difficulty here, I say, for the defendants is the might, because it can't be said in my submission that the discretion to order an account of profits in this case was an unreasonable or irrational exercise of that discretion.
So you're just up to your luck whether the judge thinks it's right or not. Surely there's got to be some criterion. You can't just say one judge thinks that innocent infringement should be met with an account and another one doesn't, so each is reasonable.
Well, I think your lordship has quite precisely expressed a sort of form of exasperation behind some of the submissions on the other side of the room, and this is what I say is one of the things that's totally incoherent about my learned friend's submissions on the account of profits. They positively assert that the question is a matter of discretion to be exercised on normal equitable principles.
Well, you seem to be agreeing with that. You were giving that as an example of where it could be a discretion. I'm finding your submissions equally exasperating at the moment.
I do agree with that, but your lordship didn't let me get to the incoherent part, which is that they also say, to challenge this decision, that the wrong test was applied. And I say, well, that's just completely wrong, because tests and discretions are apples and oranges. And the Court of Appeal did precisely the right thing, which is look at all the circumstances of the case and decided in a reasonable exercise of discretion to order an account of profits.
Really, strict liability tort isn't an infringer innocent?
My Lord, yes.
Well,
sometimes.
But you're accepting this as a overall principle. So, for innocent infringement of a strict liability tort, it's a factor to be taken into account.
Yes, absolutely. And
so the company could earn massive profits and say, well, they're innocently earned. Okay.
Yeah. Yeah, it's a strict liability tort. There's no blameworthiness that's necessary to establishing the tort against the wrongdoer. And that's why I referred at the very beginning of my submissions to Section 14, which refers to the remedies that are available after that strict liability tort has been demonstrated. I also want to step back from these submissions and the judgment itself, just to observe that the account of profits is often something that the defendant will want when the profits are known, because that's their opportunity to take away from the profits that will be disgorged in the process of accounting to the successful claimant. I don't accept that it's fair to the Court of Appeal to say that the language in which this judgment is cast a burden on the infringer to prove why the account of profits ought not to have been ordered. I think it's a perfectly standard and orthodox description of the law to say that the successful claimant is entitled to elect to have an account of profits, and that their election is an important factor in the judge's decision. Well, may I just have a moment? There's one final point on this, which I think is neatly encapsulated, if I may take your lordships to it, in paragraphs 50 and 51 of the Court of Appeal judgment on page 354, which I invite your lordships to read. What I'd say about this, my lords, is that if you accept what my learned friend is arguing for, that improper and unconscionable should be treated as meaning the same thing, and that unconscionability is required, you actually afford the defence at the stage of the exercise of the discretion to order an account of profits, which isn't available on the substantive law. So in paragraphs 50 and 51, paragraph that I'd already taken your lordships to, paragraph 61, that is what I think is being expressed by Lord Justice Birth, where he's saying, well, the Ahmeds have prayed in aid various matters, no knowledge, etc., in support of their defence, but none of those things are defences.
But it's perfectly coherent to say you don't have a defence on liability, but something, nevertheless, which didn't give you a defence on liability means the court shouldn't award one particular remedy rather than another.
Yes, and I think, my lord, that's absolutely right, and that's why there is this discretion. But it has to be exercised in such a way that doesn't undermine the fact that there can be innocent infringers and doesn't undermine the strict liability character of the tort. My lords, I have nothing further to say on account of profit, so unless I can assist further, I'll hand back over to Mr. St. Quintin.
Thank you, Mr. Brown.
Thank you.
My lords, just in respect of the reference that my Lord Richards asked for, the first instance judge's decision on the salaries issue is page 397 to 399, the big bundle, and it's his paragraphs 91 to 97 and then 102 to 103.
Thank you.
My Lords, I turn then to Advanced Lifestyles appeal. I will deal with ground 1 and then hand back to my learned friend, Mr. Brown, to deal with grounds 2 and 3. I'm going to have to, I think, rattle through some of this, unfortunately. But my Lords, this ground 1 appeal is in respect of the account of profits, and the principle in issue here is whether a joint tort feasor can be liable for profits which were received by his or her co-tort feasor rather than received by himself. Prior to the judgment of the Court of Appeal in this case, there was no Court of Appeal judgment on this. There's no judgment in this court that provides much assistance, and there's a dearth of authority at first instance as well in my submission. The first case I should refer you to is in my written argument at paragraph 16, which is the Hotel Cipriani case. It may be convenient just to take you to my written case on this, because all of the first instance decisions are conclusory in their expression of the principle. In Hotel Cipriani, paragraph 16, I've set out the entire...
Where's the electronic bundle?
Sorry, my Lord, it's page 255.
Thank you.
So this case is against me, and it's the second sentence of the extract there is the only discussion that Mr. Justice Briggs, as he then was, went into, and he said that an account of profits operates against each defendant separately, requiring to disgorge such profits as are shown to have been derived by that defendant from the relevant infringements. So that's the principle that the judge below in the Court of Appeal held to be correct. In my submission, it wasn't correct.
Well, it seems a fairly strong argument to say that if you're asked to disgorge profits that somebody else has made, you're not giving up a gain, you're just simply penal.
Well, my Lord, in my submission, it isn't. And that depends upon the whole basis of the account of profits, and that's how I wish to develop this point of my appeal. Before doing that, if I may just scroll back up in my written submissions to paragraph 11, just to show you the contrary view. This is a decision of the High Court of Ireland, Mr. Justice Costello, where, in essence, the opposite proposition was set out. I could invite you just to read that, if I may.
It doesn't really address the point, does it? It says that just as an awarded damages could be made,
yes,
joint and several tort feasors, so could an order for an account.
So
it doesn't address my Lord's point as to the fundamental difference between the two remedies.
It doesn't, but in my submission, the reason for Mr. Justice Costello's decision there, and the reason that I urge upon you, is that actually at their foundation, both of these measures of a financial remedy have the same purpose, and that is to identify an amount of money that should be paid by a person who has wrongly used a right belonging to another to the right owner. And if I may develop that, that's supported in my submission by the decision of, the speech of Lord Nichols in the Attorney General and Blake case. So that is in the bundle at...
At that very high level of generality, it's true.
Yes. But because of that, my Lord, when one comes to speak of damages, even user-based damages, which aren't, in fact, to compensate for a loss, they're there as a measure that the common law has arrived at to identify the benefit to a misuser of a right from that misuse as a way to measure the value of the financial remedy. That is something that conventionally is paid by joint tort feasors, despite the fact...
But it's not any longer, at least, conceived as giving up a benefit since Supreme Court...
It is commonly termed as damages.
It was, yes.
But in my submission, at its basis, it is a restitutionary measure. It is an amount of money that someone is due to pay to the rights owner as a consequence of their causation of misuse of the right, despite the fact that benefit didn't accrue to them.
Well, that's not what One Step and Morris Garner decided. Only.
Well, my lords, yes, in that case, about what's essentially the same measure called negotiating damages, a way to assess how a contracting party would have demanded an amount of money when, if they were to have agreed with...
And Lord Reid discusses user damages
yes.
in the same context in that judgment.
So,
he characterises them as compensation for loss.
Well, my lord, in my submission...
I know it's a different kind of compensation for loss
yes.
than for loss you've shown that you've actually sustained, but it's not a restitutionary remedy.
In that context, it's not for the invasion of a right. It's for the breach of an agreement. And essentially, in my submission, the underlying principle of that is that I wouldn't have engaged in this agreement with you at all unless you'd paid me this much. I wouldn't have given you you wouldn't have been allowed to do the thing you have now done unless you paid me this amount of negotiating damages. So that is, in that context, perhaps a loss. To the extent that these damages calculated on this basis are called damages in an intellectual property context, in my submission, that's a post facto justification of the restitutionary approach that was the original basis for the user damages.
But it's different from disgorgement of profits.
It is different from disgorgement of profits, but the purpose in my submission of the account, of the measure of profits, I'm at risk of repeating myself, but it's that it's a way of calculating a financial remedy that results from the misuse of the property right. And both, in my submission, both primary and joint tortfeasors are liable for that misuse, and both should be...
But whose profits are being accounted for?
It's the profits that result from the acts of misuse. So it's the profits wherever they've ended up. So it doesn't matter in my submission that they are not necessarily, or not all, in the profits of any of the particular joint tortfeasors. It is the necessary element is that they are profits caused by the infringement. And that, in my submission, that's the basis on which it's appropriate for that measure of financial remedy to be assessed. In my submission, my lords, there is no penalty in doing that, because it is simply a measure of loss.
It's not a measure of loss. Account of profits is not a measure of loss.
Sorry, you are quite correct, sorry. It is a measure of the financial remedy for the misuse of the Act. That's the purpose.
Well, it's a disgorgement of profits.
It is a disgorgement, in my submission, my lord, of the profit made as a consequence of the Act. And there would be, in my submission...
Sorry for interrupting, but say, for instance, a large retailer
yes.
employs a buyer.
Yeah.
And the buyer, as an employee, then procures the company to
yes.
be guilty of a trademark infringement. And the employee's wages stay exactly the same. On your argument, he's liable for disgorging all the profits of a multinational corporation made out of that.
My lord, yes. And that seems stark, but equally he would be liable, conventionally, I don't think this is an issue, he would be liable.
Surely that's not your submission, is it? I mean, I assumed you were going to answer by saying, well, the court would have a discretion to order the employee to pay the profits made by the corporation, but you're not saying, are you, that the claimant would be entitled to an order?
My lord, in my submission, the court would have a discretion as to whether to order an account against that person.
Exactly. Or whether to make him... Well, you wouldn't order an account against him. You order the account against the corporation, yeah. And then make an order that the employee pay the profits shown to have been made by the corporation.
Well, my Lord, yes.
This was Mr. Brown's point. You don't need to have an account if you know what the profits are.
Yeah, well, my Lord, quite. But there would be a discretion to order as to whether that individual was ordered to make payment of those profits.
Yes, exactly. So
There is a
distinction between, on any footing, distinction between ordering disgorgement of profits on the one hand and common law damages on the other.
My Lord, in respect of whether the remedy is ordered at all,
correct.
Yes. But when one comes to assessing the remedy, in my submission, at a later stage, then...
But you are saying, in answer to my Lord Stevens, that the court could, if it thought it right, order the employee to pay some or all of his or her employer's profits.
But, my Lord, yes. And I recognise that seems to be a stark proposition, and I explain it this way.
Well, if you're accepting my Lord Richard's way of putting it, what did the judge do wrong in this case, then?
My Lord, in this case, so once the account is ordered, in my submission, then the assessment is correct. So I think my answer to Lord Richard's question is that it is correct there is a discretion. The court could say there are special circumstances in respect of the employee, and my Lord Stevens' example, to say, well, I'm not going to order this remedy against you. But if it is ordered, then the remedy...
I mean, if you know how much the employee's gained, if anything, and how much the company has, and it's patently unfair to order the employee to pay over money that he or she has not in fact gained.
So my Lord, this is the issue. And my response to it is that the way of resolving that perceived unfairness is through contribution. And that is the way that the court approaches.
Sorry, let me get this absolutely right, because now I'm puzzled as well. We know the position for common law damages.
Yes.
So joint tortfeasors are jointly and severally liable, and then there can be contribution claims. But we're here talking about an account of profits in equity. It's an equitable remedy, not a common law remedy that we're talking about here. And do I understand your submission to be that if you've got joint tortfeasors and the court considers it right, by reference to the criteria that Mr. Brown addressed us on, to order an account of profits, then the claimant is entitled to an account of profits against all the tortfeasors and an order that all the tortfeasors pay the aggregate profits made, and that they should then the tortfeasors then sort it out amongst themselves.
No, yes.
That's what possible authority is there for that proposition?
Well, my Lord, it starts, in my submission, the justification from it begins with the contribution.
I'd like to know where the authority is. Is there any authority, apart from the passing reference by Mr. Justice Costello, for this proposition?
My Lord, there are no other authorities on the proposition. No.
It's all orders for accounts of profits have always been made, haven't they? Is this right? Against the person who has received the profit.
My Lord, yes, but other than in the Cipriani case and the House of Spring Gardens case, the issue as to what happens with joint and several liable tortfeasors or the invasion of a property right.
But this could happen, it's not just joint tortfeasors, this could happen in any claim against people in a fiduciary position, for example, trustees, directors, and so on.
Well, so in respect of that, so I'd say there's a distinction between the invasion of property rights cases where there's joint tortfeasors and the fiduciary cases. There are fiduciary cases
It's the same remedy. It's the equitable remedy of an account of profits.
In my submission, it's the same approach to calculation of a sum. So the remedy, in that sense, yes, the remedy is the same, but against whom it is ordered to take place, in my submission, can look different.
If you're saying that the fiduciary cases are restricted to an account of profits against those who are thought to have received the profits and restricted to that, isn't that a good illustration of what the equitable remedy is?
So, my Lord,
this isn't a remedy that is different depending on the cause of action, is it?
Well, the calculation of the remedy is different. In my submission,
it's not just a calculation. You're suggesting a substantively different remedy.
I am saying, my lord, that in the basis of awarding profits for an intellectual property right infringement or a property invasion is merely a pragmatic way.
Why is it not similarly pragmatic, where you've got a group of defaulting directors to say that, well, they've all caused the company to divert an opportunity.
Yes.
They should all be liable to disgorge all the profits that have been made, whether or not whether they were received by each of them.
Well, my lord, in the fiduciary's context, there are cases where that has happened.
Well, that's very important to know. That's critical.
Yes.
I asked you if there was authority for this, and
but sorry, my lord. Yes, I was focused. It's a part of my case. So I'll set the groundwork a little bit more clearly. I say that the foundational principle for intellectual property rights infringements is that the measure is to say, here is a financial remedy to value something you should receive having your right invaded. I say that's different in principle to the approach with defaulting fiduciaries and their assistants. There are cases for defaulting fiduciaries that go in each direction.
Well, so, I think I'd be very interested in any cases where an account of profits has been ordered against someone who didn't receive any profits or was held liable to pay profits they hadn't received.
So my lord, well, there are four that are referred to in my written argument. So the principle, two of them don't really help very much, because they are, again, conclusory. It's clear from the judgments that an order was made against all of the defaulting parties and their assistants together. That's the Comax case and the ostrich farming case.
Sorry, wait, this is in paragraph what of your case?
So, my lord, those two cases are referred to in paragraph 21.3 on page 258.
Thank you. So, those two cases... right, okay.
They're the weakest of the four.
All right.
Then there is the decision of Justice Manson in the Supreme Court of British Columbia that I referred to in paragraph 21.1. And this has little extra, I accept, but has more. And the quote from Justice Manson there is set out at the bottom of page 257.
Sorry, when you say 257? I see.
So the finding was made there. The best case for me on this point is one I referred to in 21.4, which is
CMS Dolphin.
My lord, yes.
Right.
And it's paragraphs 98 to 105 of that case which dealt with the particular discussion, and I think it's going to be important to look at that. The relevant page, excuse me, for that judgment in the bundle is 2273, which is the beginning of paragraph 98 of Mr. Justice Lawrence Collins' judgment.
Sorry, what page of the bundle again?
2773.
2773?
Yes, 2773. And it's, my apologies, it's reproduced full size, but the text is quite small in any event. So it begins at the very bottom of that page, paragraph 98, effect of use of a corporate vehicle.
I'm sorry, what the page number again?
Apologies, 2773.
Yeah, thank you.
Well, the fastest thing might be if I just asked you to read to the end of paragraph 103, which is about a page and a half later.
Are these cases where the relevant person has effectively channeled the profits into another entity and consequently is still liable to account even though that person may not have the funds in their own account at the time?
Yes, so the person who is paying the account in these cases is the nexus between, or is the fiduciary in essence. They're the nexus between the wrongful act and the profits made by the company. But the proposition I take from these is that it is the case that fiduciaries are ordered to pay profits that they themselves have not made.
Or profits which they themselves have channeled into other entities.
Or if I characterise it more as profits they have caused other entities to make through their wrongful acts. Now, in this case model, paragraphs, well, you see there's some analysis that Mr. Justice Lawrence Collins, as he then was, undertook, having posed the question in paragraph 98 about how one should deal with a situation such as that was before him. He cites a number of cases which I'll come back to briefly to discuss, but it's paragraph 103 where he reaches his ultimate conclusion on this point, though the following two paragraphs are also relevant to it. He indicates, ultimately in the final sentence of paragraph 103, that his conclusion that directors being equally liable with corporate vehicles is that they have jointly participated in the breach of trust. Now, in my submission, that is very much the same and even clearer, more clearly, the position in respect of joint tortfeasors for intellectual property infringements. They have not only participated in, but in circumstances of a case such as this, have procured the acts. And they therefore should, in my submission, be liable to account for those amounts. Now, this case has been analysed later in other first instance judgments, particularly Mr. Justice Lewison, as he then was in the Ultraframe case, and it has been disagreed with. So Mr. Justice Lewison considered the same point and came to the opposite conclusion ultimately. In my submission, however, Mr. Justice Lewison did so by going wrong in his interpretation of two of the cases that Mr. Justice Lawrence Collins particularly relied upon. So looking back up in paragraph 100 of CMS on page 2774, there, His Lordship there set out an extract from the Cook and Deeks case, and he held that that was a case in which a common account had been ordered to be paid by all of the directors together. He says in the extract, it breaks, it's a sentence that breaks over page 2774 and 2775. It could be disputed that the Dominion Construction Company acquired the rights of these defendants with full knowledge of the facts, and the account must be directed in form as an account in favour of the Toronto Company against all the other defendants. Now, there's slightly curious language there, just to explain Toronto Company against all the other defendants, because Mr. Cook was a shareholder in the Toronto Company and he had brought the action. The Toronto Company had been made formally a defendant to the claim, but it was its loss that he was seeking to recover. That's why that language arises. But Mr. Justice Lawrence Collins took that an account in favour of the company against all the defendants to be an indication that there was a joint liability to pay that account. Now,
it seems from the paragraph at the foot of 2774 that, I mean, the way it's expressed there, at any rate, is that the Dominion Construction Company, which was their company, I take it, acquired the rights of these defendants, the directors. So somehow they had acquired the profitable opportunity and then passed it on to their creature company, what seems to be what is being said. So they had actually themselves acquired the property and hence the profit-earning potential. I mean, I'm just taking it from that sentence. That may not be correct.
Well, that is a fair summary.
That's quite explicable then, I would have thought, that the account would be against them all.
But the explanation for it, my lord, or the consequence of it, perhaps more accurately, is that the directors are then made to disgorge, if one uses that term, to pay profits
which they chose to put into this Dominion Construction Company.
Well, perhaps.
Well, that's the way it's put, anyway. I mean,
as the purpose of the discussion in CMS that Mr. Justice Lawrence Collins was undertaking was to deal with a situation where a remedy is sought against a director, where the profits are made by a company which itself had genuinely entered into trade.
Yep. No, I see the application. I see that point. I just on this particular.
Mr. Justice Lewison in Ultrafame did also reviewed exactly that. In Cook and Deeks, again, as with lots of these cases, there's not any particular analysis in the judgment as to what led to that result. But that result of an account, seemingly from the language against all of the directors jointly, was ordered. Mr. Justice Lewison said, well, I'm actually not, it's not clear authority for that proposition, on the basis that he held it could equally mean separate accounts against each of the defendants.
I see.
Although in my submission, the language actually doesn't permit that result. The other second basis on which Mr. Justice Lewison, as he then was in Ultraframe, disagreed with CMS was in respect of what Mr. Justice Lawrence Collins said in his paragraph 105, which I haven't asked you to read yet, but perhaps I should. Well, I will now, in fact. I asked you to read 105, which goes from the bottom of 2775 to the top of 2776.
This would seem to indicate that the proposition that Justice Lawrence Collins is asserting is that where a director puts the profit into a company in which he has an interest, he may be accountable for profits.
No, my submission, my lord, that's not what the case was about. In fact, so Mr. Gulliver, in that case,
Well, he's saying that, in 105, he's saying this is not authoritative for the proposition that where a director puts the profit into a company in which he has an interest, he's not accountable for the profits. So I was just saying the corollary would seem to be that the proposition that he's asserting is that the director may still be accountable for profits if he's put them into a company in which he has an interest.
My lord, yes. And that was what he was really addressing in that case. Now, the facts of that case were simply that Mr. Gulliver was the chairman of a company. He had 4 co-directors. The company wished to buy another business. There was a proposal that the company didn't have enough funds to invest in that business, so they need to raise money from elsewhere. The directors all put money in except Mr. Gulliver. Mr. Gulliver instead obtained other people to invest in the company, some friends of his, and actually companies in which he had a small shareholding. The other 4 directors were ordered to disgorge the profits that they personally have made because they breached the no profit rule. Mr. Gulliver was not ordered to pay anything because he hadn't breached the no profit rule, he had made no profit. It was decided by Mr. Justice Lewison, and I should say by Mr. Justice Christopher Clark in another case, the Nova Shipper Nicotine case, which I also referred to in my written argument, that this was authority for the proposition that that a fiduciary cannot be ordered to account for profits that he has not made. The distinction, my lords, in my submission where Mr. Justice Lewison went wrong was an assumption that Mr. Gulliver had done anything wrong. He seems to have held that Regal and Gulliver, was authority for the fact that because Mr. Gulliver wasn't ordered to pay profits that he hadn't personally received, that no fiduciary was due to pay profits they hadn't received. But the crucial part of the case, as Mr. Justice Lawrence Collins held in the 4th line of 105, simply Mr. Gulliver wasn't liable because he hadn't made any profit, he hadn't breached any duties, he couldn't have been. It wasn't a case about the remedy, it was a case about the liability. So in those 2 ways, in my submission, Mr. Justice Lewison went wrong. The final way Mr. Justice Lewison distinguished or said CMS wasn't correct was in respect of paragraph 103, and perhaps the best way of taking you to this, my lord, is explaining this is simply just to take you to Mr. Justice Lewison's judgment, which is at page 1663 of the bundle. It's paragraph 1574. If I could ask you to read that, please. So well, to take from that, even if Mr. Justice Lewison was right and Mr. Justice Lawrence Collins was wrong, one of the bases on which, and in my submission, an important basis on which the distinction arises is to say, well, the approach to liability in a wrongdoing fiduciaries cases that Mr. Justice Lawrence Collins took was wrong, because there isn't a concept of joint participation in that scenario. But that is not the case in my submission in an intellectual property infringement matter. And so even if the distinction, if a different approach is to be taken in joint liability cases, then, in wrongdoing fiduciary cases, then it's still justified in joint liability cases in intellectual property rights infringements. So, my lords, those are the cases on fiduciaries that are, in my submission, in my favour. I finally wish to, on this point, return to one point that I think arises from the question that my Lord Stevens asked me about the potentially wrongdoing buyer in a supermarket organisation and the propositions of unfairness that arise from these points. In my Lord Stevens' example, there's no question but that person would be, if they were jointly liable for the tort, would be jointly liable for damages, which in a very large company might be huge. That's not deemed to be penal. That's not, in my submission, unfair. And the reason it's not unfair is because it can be accommodated, or at least solved, the burden on that particular person by a claim for contribution. And in my submission, there's nothing that distinguishes that scenario from an account for profits that have been received by another. There still can be a contribution claimed by one from the other.
Is there some principle of equitable contribution?
There is a principle of equitable contribution, but I rely principally upon the legislative.
Well, that seems very difficult because that's dealing with compensation for loss.
Well, in my submission, no. It deals with cases where the same damage is incurred as a consequence of the acts. And that means, in my submission, that two parties who are liable for the same tort are capable of giving a contribution. It isn't limited to compensation. And as I set out in my written argument, my learned friend disagrees with my analysis of these cases, but I've set out in my written argument cases where the application of that statute has been more widely than things which would traditionally be called damages. So that's
well, there's a dispute about whether it applies to restitutionary claims, but those are claims where there's been some transfer of value from the claimant to the defendant. Not claims where it's simply a matter of it's never been applied, as far as I'm aware, to an account of profits.
I don't know of an authority that has applied it to an account of profits, my lord, but in my submission there's no difference in principle. And the requirement the Act has is that the parties amongst whom contribution might be made are liable for the same damage. And that's been said in those cases to equate to harm. In my submission, that's broad enough to encompass infringements that resulted in an account of profits. So,
well, you quote the Section 6, which
yes.
says a person is liable in respect of any damage for
yes.
the purposes of the Act if the person who suffered it is entitled to recover compensation from him in respect of that damage.
My lord, yes.
So that is the word that the Act uses, compensation.
My lord, it does use that word in my submission. It isn't intended to be limited to...
An account of profits can't surely be conceived as compensation, even on the broadest view of that term.
In my submission, well, it is not compensatory. I have to accept that. That statute in my submission, properly analysed in terms of damage, not meaning damages, uses compensation merely in reference to financial remedy. But as a fallback position, as I set out in paragraph 42 of my written submission, my lord, contribution can also be made in equity. Lady Justice Arden, as she then was in the City Index case, held that still existed even after the passage of the Act.
I'm sorry.
It still existed. The availability of equitable contribution still existed after the 78 Contribution Act had been passed.
So just to go back to the unfortunate buyer.
Yes.
My understanding is you said it's a two-stage test. First of all, at the discretion stage, that is whether or not to order an account of profits. The factor that enormous profits have been made by the company and no profits have been made by the individual should be taken into account. And it should be taken into account at that stage in deciding whether to order an account of profits.
Could be, yes.
Could be. But it's totally irrelevant once you've got over that hurdle.
Yes.
Right. Was that factor taken into account at the first stage in this case?
My lord, no.
Is it right that in this case the reason for the refusal of the account was simply that there was no jurisdiction to order the account?
There wasn't a refusal of the account. The
as again,
was the profits made by the company.
That's what I meant.
Paid by the people who hadn't received them.
That the judge and the Court of Appeal said, well, there's no power to do it. Is that
not no power? But the approach to be taken is to identify, they held as only to identify the profits received by the particular tortfeasor.
Yes, I sort of see that. So that seems to be saying the court won't order an account of profits, save in respect of the profits received by the by that particular defendant.
That is what the courts below held, yes.
And you say that's wrong.
My Lord, yes.
And you say that therefore infects the exercise of whatever discretion they had. They got it wrong.
My Lord, no.
You say they got it wrong.
No, I don't say they got the exercise of discretion wrong.
You say they didn't exercise.
That's what I mean. They didn't
recognise
exercise discretion.
No, my Lord, they correctly exercised, in my submission, the discretion to order an account in respect of the individuals.
Yes, I follow that.
And that was a correct exercise of their discretion, in my submission.
But they should have. Sorry.
Why, how do you have a claim then for anything else?
Sorry, my Lord, I don't follow the question.
Well, I thought you were arguing that they were wrong not to award an account of the whole profits.
My Lord, when they came to the calculation of the profits, in my submission, they should have taken into account all of them.
Well,
profits made by everyone.
Well, that's the point. And they said they couldn't do that. Is that right?
They said that it wasn't part of the calculation to take into account profits made otherwise than by...
You're making it sound like a matter of mathematics, but I'm not sure it is. It's more a matter of principle, isn't it? That they were saying they couldn't make defendant A accountable for profits received by defendant B.
That is what they held, yes.
Yeah, they said the court couldn't do that. Is that right? Or the court... Was it the court couldn't do it, or on the facts of this case shouldn't do it?
No, it was the court couldn't do it.
Couldn't do it.
Yes.
And therefore, they, as my lord said, they never got to the stage of exercising a discretion.
In respect
of that.
That account more widely, my lord, yes.
So you say they were wrong, and the question then is that if the court has a discretion, who does it fall to us to exercise the discretion?
Well, if you were to hold, my lords, that I'm correct on this ground of appeal, and that therefore there is a preceding question to be addressed, which is that there is a discretion to determine whether an account of that broader scope is going to be exercised, then yes, it would seem to me it would have to be.
We'd either have to remit it, or it would be for us, would it?
My lord, yeah.
I just wanted to see where this led.
Yes. Yeah.
Okay, thank you.
My lords, I'm going to address now the question of the loan, and it's useful to go back and just look at how this came through the courts below. So we can start, please, on page 399. Paragraphs 98 through to 101, please. So, my lords, your lordship can see the way that the question of the loan resolved itself at first instance, which Mr. Ahmed was disbelieved on his case that he repaid it. At that time, he was relying on the non-pursuit of him by the administrators in support of his claim that he had repaid the loan. And if we then turn to page 358 in the bundle, paragraphs 70 and 71 contain the reasoning of the Court of Appeal in respect of the loan, overturning the decision at first instance. and I shall deal with the fact in terms of the structure of my submissions that dissolution postdated trial and predated the appeal. I'll deal with that at the end before coming to the question of bona vacantia. For present purposes, what I want to underscore is that the decision of the Court of Appeal is predicated on Mr. Ahmed still owing an obligation to repay D11, the company.
I don't really understand why him borrowing money from the company is ever treated as a profit in the first place. It wasn't even dealt with pro rata, was it, like his salary, that sort of 10% of this was money that came from the infringement? Just the fact that the company had lent him money was somehow treated as a profit he'd made from the infringement.
Yes, and it's an interesting observation, and I accept that there's a difficulty there, particularly given what my Lord Richard said earlier, that this wasn't a claim that was advanced on a tracing basis. And that's why I say that the question of the loan resolves itself evidentially. And it was said by the judge at first instance that it wasn't shown that the money came from other than the infringing profits. But I accept there's a difficulty in relation to the loan.
That seems to be reversing the burden of proof.
One might say. Or one might say that given the ease with which he could have evidenced that he'd repaid the loan.
But repayment's one thing,
yes.
But whether it was ever a profit from the infringement is a different thing.
My Lord, I accept that. And what's unusual about the judgment is it seems to have been treated almost as if it was a tracing type claim. So, well, those monies in his hands are profits that derive from the infringing activity. And I accept there's an awkwardness about the judgment in respect of that. What I'm going to address first is assuming that the fact of dissolution is something that I can rely upon, and I'm asking your lordships therefore to bear with me until I get to, of course.
Do you accept that if the loan was still outstanding, it's not a profit?
Well, outstanding to whom, my lord?
Well, never mind. I mean, perhaps go back to my lord's question.
Yes.
Is the making of a loan a profit in the hands of the borrower?
I accept that if the loan was outstanding to the company, then it wasn't a profit. What's interesting about the question is in the hands of the director defendant.
Does it matter what does it matter so far as whether it's a profit, who the borrower owes the money to?
He's assigned the loan, let's say.
Well, I'm going to come on to say that doesn't matter. And in respect of bona vacantia, what one has to look at is...
I mean, okay. So you say if the loan was still outstanding to the company, there would be no profit in the hands of Mr. Ahmed.
That's the important caveat, because...
You do accept that?
I do accept that. Suppose it was transferred back, my lord, to the company. So the company made profits wrongfully, loaned them to Mr. Ahmed, and then they were transferred back in the repayment obligation. Then in those circumstances, I'd be able to say for the claimant that those were profits in the hands of the company. But I accept that if there was an outstanding loan obligation in the hands of Mr. Ahmed, they weren't profits in his hands as a matter of law.
Yes.
Does that help?
Very much so, yes.
So moving then to address the point, and again your lordship is going to have to bear with me very briefly, if I could bring into play the fact of dissolution, then I say that this part of the judgment doesn't make sense because the loan obligation to the company could not subsist because the company did not subsist and the company needed to subsist for it to have a right as against Mr. Ahmed for the loan to be repaid. That is a function of, and I needn't take this panel to it, Section 1012 Companies Act.
Yes, I understand that. I mean, so on dissolution, obviously the company ceases to exist. It can no longer be a creditor or have any rights at all. But Mr. Ahmed, the benefit of the loan vests in the Crown as bona vacantia, and Mr. Ahmed now owes the money to the Crown.
Yes, if
so you say at that point he's received a profit, do you?
Well, he still has the money that represents the profit.
He still has an outstanding obligation, but owed now to the Crown by operation of law.
Yes. And
why is there a profit in his hands at that point?
Well, can I just check, if that's accepted as a matter of a correct legal proposition, then I'll move on to address precisely your Lordship's question.
I can't imagine there's any dispute about that, is there?
Marvellous. Well,
I don't know that Mr... Anyway.
In that case, I'll address bona vacantia. So, it's accepted as a matter of principle and law that the obligation to repay, or rather the right to claim repayment, vests in the Crown. Indeed, it's never been Lifestyle's position that that wasn't the case. Now, the Ahmeds rely now on the fact that they say the obligation to repay still exists, but the person to whom the repayment has to be made is someone else. In our submission, that's not an answer to...
They accept that it still exists, the obligation to repay, because otherwise they'd be paying the Crown.
My Lord, I missed the beginning of your question.
Do they accept that there is still an obligation to repay? Because I thought they wished to introduce into evidence before the judge their contention that they had in fact repaid, and they put forward some further evidence.
Yes,
I was rather suspecting that they would be relying upon that further evidence if the Crown ever came after them, or indeed if anybody took an assignment from the Crown of the loan and then went after them.
My Lord, you're absolutely right. Yeah. So they sought to rely upon the administrator's report from May 2020, and that was deployed in support of the contention that the loan had been repaid, which was the contention that was disbelieved.
Yeah. But that wouldn't bind the Ahmeds in relation to the Crown, would it?
Not necessarily.
Well, yeah, it wouldn't.
But do you say that, what do you say in principle about it being bona vacantia? Do you say that that doesn't count as an obligation, or what?
No, I don't think I could advance that submission with any intellectual honesty. What I have to say is that, that there's what I'm going to say is that it has to resolve pragmatically and evidentially, and that there's no evidence whatsoever that the Crown would adopt a different stance to the stance adopted by the administrators, which was formally relied upon by Mr. Ahmed, as I've just been discussing with my Lord Stevens. So the chances of this loan obligation, will my Lord bear with me?
Forgive me, what was relied on by the Ahmeds?
The Ahmeds relied upon the administrator's report.
Well, they didn't, because they weren't allowed to introduce it into evidence because you opposed its introduction. So isn't that the point? It's not in evidence.
My Lord, that's wrong. I'll tell your Lordship why it's wrong.
I see.
I'll deal with that now, discreetly, if I may. Right. So the Court of Appeal held, and this is at paragraph 90 of its judgment, that Lifestyle had opposed the introduction of that evidence. And it pinned Lifestyle to a position which Lifestyle actually never took. My learned friend, Mr. St. Quintin's submission in respect of that evidence was simply that it was insufficient to demonstrate what Mr. Ahmed deployed it to demonstrate, which was that the administrators weren't pursuing him, and that was because he had repaid the loan. So it's quite unfair for the Court of Appeal to pin Lifestyle to that position which it never took. And actually, if one reads the judgment that deals with that, one can see that the judge, agreeing with Lifestyle, concludes that notwithstanding that evidence, it wasn't sufficient for him to reopen his decision on the question of the loan. So I have to...
So he did admit the evidence, you say, but didn't
why
place
is it relevant
weight
anyway? I mean, if the case is that the lender, the company, made a profit, it then used that money to lend to the director, if it then forgives the loan, that doesn't turn it into a profit that the directors made from the infringement, does it?
Well, again, it depends if one is going to look at things from a sort of technical tracing point of view, or whether one is going to look at the thing in the way the judge did, which is how does it resolve evidentially. So I think what the judge would have said in relation to that is, well, and what I say is, well, if the obligation to repay profits which have been advanced to him by way of loan has been forgiven or waived by the company, then those do represent free profits in his hands which are related to the infringing activity.
But the profit stems from the forgiveness of the loan, doesn't it?
Yeah.
That's what creates the profit. And supposing that forgiveness was a breach of duty by the directors.
Including Mr. Ahmed and
Yes.
Mrs. Ahmed.
Yes. So they'd be then liable to the company.
Yeah. Subject to questions of ratification, but none of that's in play on the evidence, so I'm not going to complicate things by dealing with it. So,
or if it's simply that the Crown doesn't go after, doesn't do anything about it, that can't make any legal difference.
Can't make any legal
difference to whether it's an obligation or not.
It doesn't make any difference whatsoever to the fact of the obligation. That's a juridical fact that I can't escape, and I'm not going to try and persuade the court otherwise. What I say is one has to look at whether or not the Bonaventure Department would ever pursue Mr. Ahmed to reclaim these monies. And we say, and this is set out in our written case, that all the indications point the other way.
But so what if they do? What follows legally from that?
Well, I say that the court has to make the decision based on the real-world position and not tie itself to some technical doctrine.
Like legal obligations and
well,
rights?
what is in the nature of the obligation if the obligation is never going to be called upon? Is that really such a real obligation, my lord? So, of course, I accept your lordship's point, and the technical correctness of it is one, of course, I rely upon in relation to the dissolution. I say we can't speak of an obligation owed to a legal person that doesn't exist anymore. So I rely on that technicality. But the judge is trying to decide the case based upon the evidence. And what I say in relation to Bonaventure is that there's no evidence whatsoever that the Crown would ever pursue a director or this director in relation to this loan. And you'll see that we've relied in our written case on the policy paper produced by the Bonaventure Department. And we'd say that because there's a dispute about the loan, I think it's safe to say, seeing as we're here, that there is a dispute about the loan, or because it's low value, or because it might be owed to someone else, that we can't simply assume, as the Ahmeds would ask the court to do, that the Crown would have any greater appetite to pursue Mr. Ahmed in respect of this loan.
Why restricted to the Crown?
Or anybody else. Yes.
Crown assigned it to anybody?
Yes, we come back to the assignment point, exactly. So I say, there's lots of nice legal points here, but notwithstanding the change of position to say from I have repaid so I don't have an obligation to repay to now I do have an obligation to repay so I win, notwithstanding the sort of artificiality and I would say unfairness of that, I say one has to look at the evidence in the case as to whether or not he would ever be pursued by these monies, which ultimately flow from, as the judge found as a matter of fact, which can't be challenged, the wrongfully obtained profits as a result of the infringing activity. I don't say, in response to Lord Legate's question, that it changes the basic legal, technical character of the obligation to whoever it is owed. I can't, as I say, advance a submission of that nature without being incorrect. I'm mindful of the time. Tax is outstanding. I can deal with it in a very summary way, mindful of the fact that we have a reply. If that's okay with your lordships, it would take me no more than 3 minutes.
Well,
So what I'll do is
we'll take you at your word, Mr. Brown.
Very well. I'm sure someone will throw something at me if I exceed that. So I'll deal with it at the highest level of principle and generality. So we urge the court to follow the approach which is set out by the editors of Lewin, which is that in respect of an account of profits, the incidence of taxation is to be ignored. And the editors of Lewin hold that for so correct a proposition that they've used it as one of their subtitles. And I'll give your lordships the reference, with gratitude to my learned friend Mr. Knox for including it in the supplementary bundle. It's supplementary bundle page 99. It's Lewin on Trust, 20th edition, 41-022 to 023.
Hold on.
I also rely, and I'll just give the reference for this, and boldly encouraged by...
so, Lewin, just give me the paragraph number again, sorry.
I think it was 41-022 to 023.
Sorry, you went far too fast.
41.
41-022
yes.
to 023.
Yeah.
Supplementary bundle 99.
Yes, thank you.
There are then, as I must accept, conflicting cases on this. There's a decision of Mr. Justice Laddie and there's a decision of Lord Justice Nichols, albeit sitting as a judge of the High Court. I commend to the court the decision of Lord Justice Nichols in John, that is Elton, continuing the theatrical theme, John and James. That is at page 1437. My lords, please read on this point from page 1444 to 1448. Finally, on the substance of the taxation point, we say that there are avenues through which the wrongdoing defendants could reduce the impact of overpaid tax, and one is the Tax Management Act, on which I have placed reliance, and I'm grateful to my learned friend Lauren Sykes KC for mentioning another part of the statutory code which might avail the Ahmeds, and that is section 555, deductibility of overpaid tax by a former employee of a company. I rely in respect of the position on tax on Whiteman and Sherry in income tax, noting that Whiteman was one of the counsel before Lord Justice Nichols in John and James. That is at page 5604 of the bundle. You'll also have our submission as to procedural unfairness in relation to the way the tax point emerged, which was in the judgment. Strident and trenchant criticism was made of James Pickering, KC, in the case of Satnam, for introducing a point upon which he decided the case in the judgment. That is what happened here. My learned friend, Mr. St. Quintin, was given from 10:46 until close of play to put in his submissions on tax. I say that was far too short a period of time, and the best point I can make in relation to that is that you have seen that the incidence of taxation point has produced submissions from leading counsel which refer to several cases as to which there's a conflict, as to principle, and to various statutory provisions that we say are in play. So that, to me, underscores the inappropriateness of the manner in which this point was raised by the Court of Appeal. I'm sure I've gone slightly over 3 minutes, but I hope I can be forgiven for doing so.
You've done.
Thank you. Those are my submissions on the taxation point.
Thank you, Mr. Brown. Otherwise, now we'll resume at 2 o'clock.